Lawyers have read it. What's the most badass I rest my case moment you've ever witnessed? I was in an accident a few years ago, the other guy's fault. He got a ticket for unsafe left turn, and I got a ticket because I wasn't wearing my seatbelt. In the section of the ticket, the cop inadvertently wrote, "Did wear seatbelt while operating motor vehicle." When I got to court, the judge asked how I wanted to plead. I asked the judge if I could ask a question first. He said, "Sure." I stated, "The ticket said I did wear my seatbelt while operating the motor vehicle, and if that's the case, I want to plead guilty." The judge looks down at the ticket and looks back at me and says, "Case dismissed. Have a good day." I did. Next story. Just a short one. Denmark's constitution states that you're to be held before a judge within 24 hours of your arrest. No exceptions. Christmas Day, we bring a man before the judge, and the whole case took like 2 minutes from the time we entered the court. Prosecutor goes, "Your Honor, the man before you has an entry ban from Denmark, yet here he is. I have no further allegations." Edit. I can see that some people are confused, so I'll take a minute to clear out some of it. I don't get it. The accused is not allowed to be in Denmark. The accused is sitting in a Danish courtroom, making it a very hard case for him to deny that he is in fact violating his entry ban. Why is it important that it's Christmas? It's implicit that none of us wanted to be in court for longer than absolutely necessary, since we had better places to be. How did you get banned from Denmark? It helps if you're a non-EU citizen and commit a crime that gives more than 4 years in prison. I don't know what this man was banned for in particular. There's plenty of people getting banned, but it is a bit complicated, not just because of international laws, but because we don't really have hard borders. It's more of a speed bump. What if the 24-hour rule is broken? Time for a classic law term. It depends. If a Danish citizen does a petty crime, there's a possibility he's just sent home. We do that with drunks, fights, junkies, etc. You don't just let a foreigner go, because how would you ever find him again? I remember a case where one of our big international oil tankers was attacked by pirates outside the coast of Somalia. The pirates were caught and held captive on board for 12 days and taken to the police station as soon as the ship was in harbor. All the pirates had to be paid a compensation because they were not held before a judge, called in via Skype within 24 hours. I hope that cleared out some of the confusion. No, it did not clear up any confusion. That's a wild story, but maybe I'm just stupid and I don't understand. Who cares? Moving on. Next story. This may not apply, but there's a Judge Judy episode where a high school girl is suing 2 boys from her school for taking her backpack and stealing various valuables out of it, and something like the following conversation happened. Judge Judy goes, "And what was taken from your backpack?" And the girl says, "My phone, my money, my headphones." And the boy says, "No, they weren't." Judge Judy says, "Excuse me?" And the boy says, "There weren't any headphones in the backpack." Next story. My wife and not me, and it was during sentencing. "Mr. Defendant, local gang boss, you stated you're not and have never been in a gang." "That's correct." "Do you have any tattoos?" "Yeah, I have a tiger on my calf and one on my chest that says GD for life." "What does GD stand for?" "Gangster Disciples." But, no further questions, Your Honor. Next story. One of my top posts ever is relevant here. For a while, my mother dated a man who really liked to act like a big shot. He was a guy that claimed to know a guy wherever you went. Anytime you wanted something, he would say, "Oh, wait, let me go to this store name and I'll talk to the owner and get you a deal." Nearly every time he did, the owner seemed like he wasn't entirely sure who this guy was. He would do crap like insist on taking the whole family on a vacation, or take everyone to a fancy restaurant, or he would show up with expensive gifts out of the blue, crap like new electronics or guitars. Eventually, the relationship ends, but not long after, we find out he's taking us to court because we owe him money. Court date comes, he presents his case first, he goes through a huge itemized list of every item he ever bought us. Every single item, from a vending machine Coke to a new sink because he broke the old one. Even a birthday cake brought for the youngest child. Once he's done, the judge asks if there is an agreement to be paid back for any of that. He says it was just an understanding. The judge asks specifically if he ever said he wanted to be paid back. He says no, that usually when someone buys you something, you pay them back. The judge then explained that no, in fact, that's not usually how gifts work, and that by his own admission, there was never an expectation to pay for anything. So, after his own testimony, the case was closed. He then appealed. Again, he presented his testimony first. Again, closed by his own words. Next story. When I was in law school, I clerked for a criminal defense legal clinic. We had had an assault and battery case where there was only one witness to the crime, which was the victim. I was sitting at the defense table with the actual attorney, another law student that worked on the case with me, and the defendant. We were all in similar-looking suits as a matter of unplanned coincidence. The victim was asked to identify the person who committed the assault in court, and she pointed to me and not the defendant. Our attorney asked several times if she was really pointing to me and if she was sure, and she said yes. The prosecutor was visibly upset, and the trial pretty much ended there, as this was a bench trial and not with a jury. It was never discussed or admitted to, but I suspect our attorney purposefully had me there at the trial because I did have a passing resemblance of the defendant. Next story. A little late, but this is one of my dad's favorite stories. So he's out of state on business, driving through some no-name town when he goes through an intersection. Suddenly, a cop pulls him over, stating that he ran a stop sign and ticketed him. My dad insisted there was not any stop sign, but the cop did not listen. Pissed, he went back to the intersection and saw that there was a stop sign hidden behind a tree and twisted in the wrong direction. Even more pissed, he went to a convenience store that was in sight of the intersection and bought a disposable camera while the clerk laughed because he saw what happened and knew what's up. Luckily, my dad had to be back there in a few weeks for work. The cop assumed that someone with out-of-state plates would just pay the ticket, and they were shocked when my dad turned up in court, calmly presented his evidence to the judge, and strolled out in 5 minutes scot-free. Next story. Not a lawyer, but my father-in-law was subpoenaed to testify in a trial. Wasn't a big case. It was to do with a car and if it had or had not been written off and if there was fraud going on. Essentially, they had a form from the garage my father-in-law had been working at. He did all their paperwork, and they put him on the bench and asked some questions. Then they handed him a form, which he had filled out for her work to be done after her accident. The lawyer asked him, "Did you fill out this form?" "Yes." "And on the right, where it says write-off, car total, did you write that?" "No." "You sure?" "Yes." "Is it possible you wrote that and forgot?" "No." "How do you know you didn't write that and simply don't remember?" "I always write in all caps like the majority of this form. That's not written in caps, so I know I didn't write it." I'm told the lawyer's face dropped, and the case was dismissed. My father-in-law said this after. "He was a bad lawyer. You never ask a question that you don't already know the answer to." Yeah, I'm definitely not a lawyer here, and even I know that. He's just totally tripping yourself up, Mr. Lawyer. That's tough to read. Next story. Kind of applies, I'd suppose. I practice mostly criminal defense. I, fairly recently, had a client who, after pleading guilty to a theft charge, contested the amount of restitution owed. Essentially, the client said, "I stole some stuff, but I didn't steal all of that stuff." The victim had to come to court to prove the value of the things he alleged were stolen. Some of those things, that my client denied having touched, much less stolen, were rare and valuable coins. To support his claim, he brought a statement purporting to be from a local coin dealer with the type of coin listed and its value. I knew nothing about coins, but I knew the judge knew a lot about coins, having collected them for years. The DA asked his questions. I muddled through my questions. Then the judge said he had some questions, and verbally ripped this guy's list to shreds. Stuff like, "You expect me to believe that blah 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 coin and blah blah condition is worth $250 when I can go online right now and find the same coin for $36? I just sat back like Vincent LaGuardia Gambini while Mona Lisa Vito was being voyeur-dired. It was wonderful to watch. Next story. Not a lawyer, but I read about this. 2 guys were being tried for robbing a gas station. A customer who saw the robbery was now on the witness stand. The prosecutor asked him to describe what he saw. He said that he saw 2 guys robbing the store and then running out, and one of them bumped into him. Then the prosecutor looked at the 2 perps and said, "Are those 2 men in the same courtroom today?" At which point, the 2 idiots raised their hands. Case closed. Next story. Was on a jury. Defendant attempted to rob a tip jar from a barista, and the barista fought back. He ran, and she tossed the empty jar towards him. Defendant claims he was hit on the head and injured by the metal tip jar. Even though we'd already watched the video and I already caught this detail, the prosecutor asked to play the video of the robbery again, and then she says, how could the barista had hit him in the front of the head when she was throwing it from behind? And he's wearing a hat. She was so annoyed she had to point that out. I almost laughed. Next story. Not a lawyer, but I once got stopped by a cop for a fix-it ticket. Basically, you have to fix a broken taillight and get a cop to sign the ticket or pay the fine. That night, my car was totaled by a drunk driver who ran off the road and hit it at high speed. Can't fix a taillight if you don't have the car anymore. So I wound up going in on my court date to contest the ticket. Say, sorry, I couldn't get the light fixed and I don't think I should have to pay. The judge gives me this look like, what's your excuse? Then I hand over the police report papers and briefly explain about the wreck. I didn't have to pay. Next story. Not so much a rest my case moment, but a memorable one. There was a deposition of a witness in a room full of attorneys. Witness is asked if he knows or has spoken with any of the attorneys in the room before the deposition. Witness responds he knows Addie X because sometimes they go to the same parties and snort coke together. Needless to say, Addie X had an immediate meltdown. Good transcript to keep. Next story. I have two, one my own and one someone else's. In mine, my client was accused of not leaving this woman alone when she wanted no contact with him. He swore that they were dating, and she'd call the police when she got mad. She swore she wanted nothing to do with him. She had a photo on her phone of him sitting on her porch to prove that he'd come around without her consent. I asked permission from the judge to look at the photos before and after to get context. Lo and behold, she had hundreds of photos of him, eating dinner with her, sitting on her couch, wearing her undergarments. It was glorious. In the other, a colleague was questioning a police officer about a consensual encounter with the defendant. Officer claimed that he in no way intimidated the client, and that the client was free to walk away at any point. My colleague said, "Officer, you think based on what you said and how you acted that any person in this room under those circumstances would feel like they could walk away?" The officer said yes, and the courtroom audience started laughing. Next story. During my divorce, my ex was on the stand lying her ass off about how she was totally not using drugs and having an affair with our underage child present in the home. Her lover was outside because my attorney subpoenaed him and he had to be there. My attorney grilled him, and what he said contradicted what my ex was saying at least a dozen times. Then my attorney put her back on the stand and made her admit every single lie she told to the judge. Her closing argument was basically that mom is a liar and has zero credibility. I was awarded primary custody of our child, the house, child support, and her druggy boyfriend is not allowed within 500 yards of the child. That was pretty badass. Next story. A friend told me this story. He's not a lawyer, but was job shadowing or something, and was in court for the day. Anyway, one of the cases was a girl contesting a stop sign violation. The prosecutor asked how long she was stopped at the stop sign, and the girl responds 40 to 50 seconds. The prosecutor asks her to look at the clock in the courtroom and proceeds to stay silent for the next 30 seconds, which is a really long time. Once the 30 seconds is up, the prosecutor looks back at her and says, "Were you really stopped 40 to 50 seconds?" And the girl was basically silent. I'm pretty sure she was found guilty. Yeah, 40 to 50 seconds, it's all a matter of perspective. Stopped at a stop sign? Pretty long time. When you're running late for a job interview, it just, you blink and it goes by. But yeah, in this context, great job by the judge bringing that to the attention. Next story. Not a lawyer, but a witness. I was called to testify in an assault case when I was a high school teenager. I had witnessed an altercation between two kids where one had been sucker punched by another, resulting in a broken orbital bone. I was asked to testify whether the kid who was assaulted instigated the fight in any way. I stated that the attack was basically unprovoked as a group of us had just been hanging out on school grounds, catching up when the attack occurred. After I testified, the lawyer for the defense got up and asked a few questions. The lawyer says, "What were you doing hanging around on school grounds during the summer?" And I say, "We were hanging around catching up with friends from my town because I hadn't seen a lot of them over the last several months." "Why is that?" I've been away from home in insert neighboring state for school the last 9 months. Is that some kind of detention facility? No, it's a college preparatory seminary. I'm studying to be a priest. No further questions. Next story. Obligatory, not a lawyer, but this happened to my wife in small claims court. Background: we lived in a small coastal town in the mid-1990s. She was attending the local community college, which was located on a steep hill. The main road ascending the hill had most of the side streets barricaded for some reason. One day, as she was driving up the hill to classes, she happened to be behind an older man in a small truck. The man attempted to turn onto a side street but found it barricaded, so he put the truck in reverse and backed into my wife. My wife said the man was apologetic as they exchanged information and gave her his phone number so they could work out how he would pay for the damage. When we called the number he gave, his wife answered and began to berate my wife, telling her that it was her fault and that we were going to have to pay. No way! Small claims court is the answer. Our day in court arrived and things looked pretty bad for us since it was our word against his, and rear-end accidents are usually considered to be the trailing driver's fault. Before making this ruling, however, the judge decided to skim the paperwork one last time. A slight chuckle emitted from the judge, and he asked the man if he remembered filling out the accident report. Yes, Your Honor. Then you probably remember stating on the accident form that you put your truck into reverse, backing into the car behind you. You've incriminated yourself and lied to the court. I'm awarding the full amount. Case closed. Consider yourself lucky I'm not charging you with contempt. The wife and I high-fived in the hall outside the courtroom. And this, my friends, is why dash cams are so important, because yes, OP is right, rear-end accidents usually go against the trailing driver, but in cases like this, if not for that self-incrimination on the report that this guy wrote, OP would have been the one to have to pay the damages, and that just sucks. Dashcam clears your name. Next story. I was once railroaded by some cops on a totally fabricated possession charge. Someone I was with had a joint in his pocket. For me and a friend, they literally emptied an ibuprofen bottle from my car into an evidence bag while laughing, telling me how I'm effed now. I'm seriously not making this crap up. I saw how the scam works when, after a nightmare in custody, both my friends took violations and paid $200 for the privilege of a night in central booking. I was having none of it. I worked from home, so could make this my hobby for the rest of the year. Bring it to trial, I said. Let's see the state spend on estimated $10K to try and convict me. Back in court weeks later, the judge glanced over the files and saw there was none of the supposed drugs in evidence. The prosecution shuffled through a bunch of papers and asked for a stay. The judge then proceeded to dress down this lawyer in the most hilarious way, telling him he was wasting my time, the court's time. This whole thing was plainly ridiculous, and the next time I was in court would likely be dragging them there on a civil case. Clearly, I had wandered into a pretty fractious relationship between these two. She dismissed the case and apologized for wasting my time. I don't think I or my lawyer had said more than one "yes, Your Honor." After a truly horrific and traumatizing experience, this made me feel marginally better about the state of our justice system. Next story. Fraud trial. Prosecution QC gets right to the point, pretty much third question into the defendant. So you earn 45,000 euros a year, have no properties, no other source of income, no inheritance, and as far as I'm aware, have not won the lottery, yet you have foreign bank accounts with X million and a Ferrari. It must simply be a coincidence that defrauded entity has an accounting black hole pretty much equal to those riches. The defendant pretty much gave up at that point. Next story. Not a lawyer, but just had a case where a guy embezzled, then sued us. He had done it by moving money to his company and calling it intercompany loans. His expert witness, who was a CPA, was asked about their one document they had produced, and she said, "As you can see, this document shows that embezzling plaintiff owes your company $650K. We had no questions and rested it right there. He should probably have gotten his CPA on the same page with him." Next story. Not a lawyer, but I used to work in the court system as a caseworker. If it was a contempt charge, I had to explain to the client that he or she had the right to an attorney and could request a continuance until he or she could meet with the attorney. One guy I was talking to waived his right to an attorney, but I'd noticed he reeked of liquor. I asked him if he'd been drinking, and he said no. I asked him again if he wanted a continuance, because I knew the last thing he needed was to go before a judge in his state. He said no, that he wanted to get it over with. This is his conversation with the judge. The guy goes, "Judge, I have nothing to hide from you." The judge says, "Sir, you smell of alcohol. What have you been drinking?" No, ma'am. I work at a bar, so I may have spilled something on myself. Sir, I'll ask you again. What have you been drinking? Well, Judge, I won't lie to you. I had a couple of Mickeys earlier this morning. Sir, it's 8 a.m. How long ago did you drink? About 6 a.m. I just got off work, ma'am. I won't lie to you. I had about 2 shots. Sir, you've shown up intoxicated in my courtroom, and nothing you say in your defense will be inadmissible in your case. Okay, ma'am, I won't lie to you. I had about 4 or 5 shots. This is bullcrap. Lock him up in the tank for contempt of court. 3 days for each time he didn't lie to me. The guy stared at me when he was being arrested. I just shrugged my shoulders. Next story. As a clerk in the district attorney's office a few years ago, there is a battery case where the victim, addict wandering the streets, likely picking fights, got into an altercation and had his hand chopped off by the defendant's machete. The day the victim came in to testify, the clerk asked him to raise his hand and swear to tell the whole truth, etc. And when he raised the handless nub, every single juror gasped for air, and we knew a conviction was on the way. This is sad, but also low-key kind of funny, I have to admit. I kind of chuckled a little bit. Had to re-record that line because it's funny. Next story. Not me, but a buddy who's a DUI attorney. In the state, he practiced in being in the car with the keys in the ignition, even if the engine isn't running. It's considered a DUI if you're intoxicated. I had a client come in, told his story to my buddy. Buddy goes to the DA after discovery and says, "Don't take this to trial." The DA says, "Yeah, right." In court, he gets the state trooper who made the arrest up on the stand, and the trooper says under oath, "I saw him with my own 2 eyes, that the keys were in the ignition." Buddy gives the cop several tries to walk it back, then has it read into the court that the car was a Prius. Boom. Instant dismissal, and the statee got into some trouble. Next story. Was hired late one day in a traffic case set for a jury trial the following morning. Usually the court will say no worries and reset the case to give you time to prepare. I showed up expecting just this. When I told the judge I'd just been hired less than 24 hours ago, she announced aloud in court and in front of the jury panel that my client knew what she did and we were going to have this trial right now. I looked at the prosecutor expecting him to agree that we should reset for a future date, but he was afraid of the judge and not a very good prosecutor anyway, so he just shrugged. I got mad and said, "Okay, then let's pick this jury." I hadn't even seen a police report yet. I only knew my client was accused of passing a stopped school bus on the right side shoulder, which is about as dangerous a move as you can do and not end up in jail. Crappy prosecutor calls 2 police witnesses who say they saw the car pass the bus improperly. The prosecution rests. I waited until the police left to resume their duties. When the judge looked at me to see if I wanted to call any witnesses, I said, "I'm going to need the court to direct a verdict of not guilty from the jury." This angry judge was losing her cool. "What are you talking about, counsel?" "Judge, we've just heard from 2 witnesses about someone passing a school bus, but neither of them indicated that my client was anywhere near there." The prosecutor had made a rookie mistake, forgot to check in court ID off his list, twice. The judge sighed. She had bullied me into this horsecrap trial, a total denial of my client's Sixth Amendment right to counsel, and had prejudiced the jury with her "she knows what she did" remark, and had wasted a couple thousand taxpayer dollars in doing it. The court directs the jury to return a verdict of not guilty. I didn't even wait for them to do it. I grabbed my client by the arm and got out of there fast, pausing to wink at the jury on the way out the door. Someone who had watched the entire thing from the gallery followed me out to the parking lot and hired me for a serious felony on the spot. I've appeared in front of that judge dozens of times since then, and she has not effed with me once. I'm still waiting for my chance to move for a bad court thingy. Next story. My mom was a personal injury solicitor, and she was basically trying to prove that the car that hit her client had caused life-changing injuries, brain damage, and belonged to X. X at first pretends not to live where he does. Then the car is found abandoned, all wiped down. The trail seems to end. Then my mom has a hunch and checks X's Facebook. He had a public profile, and his profile picture was standing next to the car in question. She screenshots them and sends them to the opposing counsel with a slightly more politely worded, "Your client's a dumb F." She's retired now, but she considers it to be one of the most satisfying moments of her career. Needless to say, she won the case and her client got a £1 million settlement and is now living in Spain. all for the want of a simple privacy setting and a touch of common sense. Next story. I once got out of a noise violation ticket. I was driving around and had my music in my car up. Cop pulls me over, gives me a ticket for the noise violation. It wasn't even that loud. You couldn't really hear it from outside the vehicle, but my windows were down, so go to court about it. My defense was, if the ice cream man can drive around blaring that creepy music, I can listen to my radio. Judge tried to keep a straight face, but got out of the ticket. Next story. I kind of have opposite of this. I had court last Tuesday as we were evicting our horrible tenants. I prepared for weeks. I compiled hundreds of papers showing that they were perpetually late, that we always fixed any issues in a timely manner, that they got super pissed when we told them we weren't renewing their lease, etc. I copied every message we had ever sent to each other, made bullet points, and numbered them for the judge to see. I typed what I wanted to say and practiced it. I was ready to be a lawyer and defend anything they may have said against me. When it was our turn, the judge asked me exactly one question. Have the tenants paid their rent? I said no, and that was it. All of my preparation for nothing. Next story. This was during a deposition rather than a trial, but it was so devastating the plaintiff later voluntarily dismissed its lawsuit. The plaintiff sued for damages after my client terminated its distributorship. The client had a 30-day notice provision tied to for cause terminations and a 60-day notice provision for terminations for any reason. My client terminated for cause, which triggered a cure right because my client really wanted to keep the relationship with the plaintiff. The plaintiff had breached the contract, which required exclusivity, by beginning to carry a competing line. The plaintiff's expert report calculated the plaintiff's damages as around $5 million for the lost sales projected into the future for 4 to 5 years. Right before the deposition of the plaintiff's expert, I found an obscure state Supreme Court case in my jurisdiction, which is the best authority you can have, that said that we were a contract and a 60-day termination provision for any reason. It was essentially a revolving 60-day contract that continually renewed until it was terminated, which meant, under the court's reasoning, future damages were always capped at a 60-day period if there is a breach of contract. This case was obscure because West, the dominant legal publisher, had not properly indexed this case as an annotation under the proper statute or in the digest system, which is where you would do the bulk of your research. I found the case while I was looking at another issue in another case. During the deposition, I took the plaintiff's expert through his damage report. Without showing him the case or what I was reading from, I read certain passages from the case describing what damages were not recoverable, without disclosing that they were not recoverable, and got him to agree that that was how his damage report was structured, and that the damages would only be a few $1,000s if they were capped at the 60-day period. I then handed him a copy of the case with the critical passages highlighted and asked him to read the passages one at a time. As each passage said certain damages were not recoverable, I would have him confirm his damage report included those unrecoverable damages. As we were about halfway through, his hands started shaking, and he started to get incredibly nervous. This was a videotape deposition, so we had a wired mic. He started pulling at the mic and acting as though he was just going to jump up and run out of the room. He looked like he was also about ready to wet his pants. We finally took a break and he composed himself some. We finished up just by having him confirm that under that case, his client's damages could not be more than a few $1,000s. The case was dismissed a few days later. I realize this is much drier than most Perry Mason moments in the courtroom. Those rarely happen in civil cases, unless they're small claims cases. You're much more likely to torpedo a case during the pre-trial work, like finding out that physical evidence has been falsified or that the disabled plaintiff is in a weekly bowling league with a 250 average, both of which I've encountered. Next story. Many years ago, my best friend was a defendant in a case and asked me to attend. A one-night stand from a little over a year prior to the event sued him out of the blue for child support. The first hearing in IVD court was to either force him to sign an acknowledgement of paternity or to legally compel him to complete a DNA test establishing paternity. The woman was being represented by some not-for-profit who sent a very aggressive attorney. The attorney acted like she was running the show from the start and ended her opening statement by telling the judge that this was a standard deadbeat dad case with a scowl in my buddy's direction. His opening statement was as follows, paraphrasing due to imperfect memory. "Good afternoon, Your Honor. I've brought a copy of text messages exchanged between the plaintiff and myself 11 months before the child was born, which I believe establishes that our single encounter could not have resulted in this pregnancy. Additionally, I have brought medical documentation of my vasectomy along with documentation of follow-up tests confirming that the procedure was successful." There is an immediate sound of whispering among the audience in the courtroom, almost entirely comprised of people waiting their turn in court. And one guy in the back laughed. The bailiff brought the paperwork to the judge. The aggressive attorney interrupted while the judge was looking over the paperwork, which pissed her off. The judge briefly told off the attorney, then dismissed the case. Next story. Condensed, because this took more than half a day. It was 30 years ago, and I still hope to see its like again. It's still long. It's worth it. I'm on jury duty. We have to sit. Charge is arson. Supposedly a farmer burned down his farm for insurance money. Prosecutor outlines what they will prove. The farmer moved most of the stuff out of a barn into a second barn, then burned down the first barn by pouring fuel around the base and setting it on fire. Prosecution calls as witness a neighbor in a subdivision that backed up to the farm who testifies the farmer moved stuff out of the barn over about a week. Neighbor noticed the unusual activity because he was outside building a deck on his vacation. Next, the neighbor saw the farmer walking slowly around the outside of the barn, pouring something from a blue gas can on the lower part of the barn walls. Farmer goes out of sight to the front of the barn, and flames erupt all along the base of the barn. Neighbor calls 911. We hear the recorded 911 call in which the neighbor says the farmer has set fire to his barn. Defense has no questions for the neighbor. By the time the fire department arrives 5 minutes later, the barn is fully involved, and they just act to contain, which is essentially just standing by since they note the nearby ground has been closely mowed, evidently to prevent spread of flame. Firemen say flames spread with a rapidity that was out of place even in a wooden barn, and they smell petroleum. Defense has no questions for firemen. Fire investigator employed by the fire department came along on the response specifically because of the "he set his barn on fire" 911 call. Says definitely arson because of the clear marks on the ground where accelerant burned, which still smelled of fuel after the fire died down. Defense has no questions for investigator. Police arrest the farmer and take him to station. More investigators said there was virtually nothing in the burned barn, ruined tools or equipment, but that there was a good supply of items in the other barn that appear to have been recently placed, including some sitting on grass that was still green underneath. Insurance company representative says the barn was insured. Defendant's lawyer still says essentially nothing. No cross-examination of any of these. Prosecution is done. Defense is up. Defense calls the farmer, and the first question is, let's cut to the chase. Did you burn your barn down? Yep. Why did you do it? It was old and rotten, with termites. Going to fall down. Not safe. Do you usually burn down old farm buildings? Yep, and my daddy did before me, and his before him. It's a farm. Are you aware that you need a permit to burn debris in this county? Been doing it that way on this farm since we had dangerous engines. Never had no permit. The fine is up to $50. Oh wait, I forgot. You're zoned active agriculture and are exempt, so no permit needed. But why didn't you tell any of this to the police? They didn't ask me no questions till after they put handcuffs on me and took me to the police station. Then they told me I'd be used against me and said I had the right to remain silent. Then some lawyer came in and told me I was going to prison for insurance fraud, and he asked me questions. I remember Perry Mason said don't talk to anyone but your lawyer, so I didn't. Did you file an insurance claim? What for? The barn wasn't worth nothing in that state. That's why I burned it in the first place. I suggested we explain all this and try to talk them out of a trial. You said you wanted your day in court. What's up with that? They came on my land, arrested me without telling me what for. Told me later it was for arson and insurance fraud and put that in the papers. All my friends, relatives, and neighbors know about this. They made me look dishonest. I want to make sure everyone knows the real facts. I figure this is better than them just dropping it and everyone wondering whether they just figured not to send an old man to prison. Defense rests. Next story. I got a violation put against my name for land I didn't own. It was the land next to mine owned by the city. I took pictures of how the violation was posted on the city's land. How the city's land was in violation of grass height laws, its orientation to my land, how the violation did not have my lot's number, but the city lot's number, and brought the posted violation to court with me. Got up to the stand, explained myself, and presented my pictures. The inspector who wrote the violation stood and called me by a name that wasn't mine, then showed pictures of a busted-up car with a bunch of weeds on it I'd never seen before. The judge raised her eyebrow and asked what address this was. He said an address that was across town from mine. I say that I also do not own that land. She removes the fines, case dismissed. Yeah, that's kind of embarrassing. I've heard of mistaken identity, but that's just like next level fail. Next story. Badass moments don't really happen in the court, most of the time. The best I've got was an auto accident case. The police report claims my client was proceeding through a red light and got T-boned on the passenger side. My client claims they are proceeding through a green light and got T-boned on the driver's side by someone else who was running the red. I asked to approach the bench and showed the judge and opposing counsel the police report. It included a sketch of how the cop said the accident happened. Then I showed the prosecutor the pictures I had of my client's vehicle, with the giant dent in the driver's side where my client says they were hit. The prosecutor points out that the police diagram shows my client being knocked into a telephone pole, so of course there's a dent. I flip forward to a picture confirming the dent on the opposite side, then back to the picture of the driver's side, and the closer-up picture of the driver's side, which includes a mostly legible imprint of the victim's license plate. The prosecutor hemmed and hawed and said he wanted to talk to his officer. The judge told him he could do that, but also that he might want to consider whether he could ethically pursue this case. He went off for a few minutes, then came back and dismissed. I don't know that I handled that optimally. I mostly do civil work. Talking things out is what I'm good at. I don't know how an experienced criminal defense pro would have handled it, and any reading this are very possibly cringing hard at my work. But it got the job done without a trial. How about, instead of the most badass I rest my case moment, the most dumbass I rest my case moment? This is civil, so it's more my forte. Opposing counsel malpracticed. It's hard to call it anything but that. He had plenty of time to answer a complaint, but didn't file an answer and didn't ask for an extension. It's now several months later, and default judgment has been granted against his client. He moves to reopen the case. In theory, this is hard to get, but everyone hates my client, so it's not as hard as it's supposed to be. He claims that a case tracking error occurred due to unfamiliar case management software, and that this should count as excusable error. I know that he's done this in other cases, so if that's the reason, he should have fixed it by now. But my side isn't planning to throw him under the bus by saying that. We just want our default judgment to stand, and we're planning to argue as delicately as possible without bringing in any outside details like that. In short, if his mistake was excusable error, it wasn't, and his client would be really harmed, probably, then the case can reopen. If he just malpracticed, then no. We're alone in small-town court. The judge comes in wearing jeans and a flannel shirt and just walks up to us and starts talking about how he doesn't want to put anything on the record if we don't need to. Sure, opposing counsel can go on record and argue his motion if he really wants, but maybe we can all talk about this, and maybe my client is open to negotiation without technically reopening the case. I'm not going to go into reasons, but that wasn't a crazy thing to suggest. My client may have been better off with an agreement than with the judgment we already had. Opposing counsel says he wants to go on record. The judge says, really? Really? He's read the briefs and he understands what happened, and he's not going to make opposing counsel go on record. Opposing counsel wants to go on record. Judge leaves and comes back in robes. Opposing counsel speaks first because it's his motion, and details, in what is now about to lead to a formal and written court ruling, how he malpracticed. The judge says, that doesn't sound like excusable error, that sounds like malpractice. End scene. Next story. I know this is weird, but actual lawyer here, sitting second chair, complex medical malpractice trial. Stay with me here. In my state, we have wide open direct examination and wide open cross-examination, which means the first time up, the lawyers can ask any questions, subject to the rules of evidence. But on redirect, you are limited to only subjects covered right before you got up in cross-exam. Then redirect is limited to what was discussed before you, etc. So the first time each side questions a witness, you can cover any subject, but the second and subsequent times, you're limited to subjects that the lawyer before you covered. You can't open new doors. Also, you can't use leading questions on direct exam, but you can cross-exam and redirect and recross. Leading questions are very powerful when you have complex facts to explain to a jury of 12, especially with experts who usually have trouble explaining things to lay people. So there's this super smart hired gun doctor, well known in the legal community, hired by the other side on direct exam, and the young lawyer who calls him has the idea that he'll do every short direct and let us destroy the guy on cross, and then he can get back up and rehab him on redirect, where he can ask leading questions about everything we talked about. He gets up and establishes credibility and qualifications and then passes the witness. The older lawyer I was working with then gets up. The lawyer says, "Hello, Dr. S. You're looking very fit today. Are you exercising?" The doctor says, "Well, yes, Mr. A. I've started biking quite a bit." "How's your wife doing, Dr. S?" "She's great. She just started a new job last week and seems to really enjoy it." "Well, that's great. Thanks for coming down today. No further questions." Thus, the other side was now limited to the above subjects only on their redirect. The other lawyer turned the color of a tomato as soon as his mistake had hit him. He stood up and asked to approach and asked for a non-suit to dismiss his case. Next story. I practice immigration law. Had a woman come in and explain that she was from Canada, had been living and working in the US without permission for decades. Boyfriend beat her up to the point where she was hospitalized. She pressed charges, and the boyfriend basically let her know via friends that his lawyer was going to call her credibility into question, since she was an illegal immigrant. Turns out her mom was born in the US and met the dad in college, which meant that she could gain dual citizenship via mom. We got her citizenship certificate expedited, and I made her promise not to tell anyone. Sure enough, at trial, defense attorney asks, "Isn't it true that you're a Canadian citizen who's been working illegally in the US for decades?" To which she replies, "No, in fact, here's my certificate of citizenship. I'm a dual Canadian and US citizen." She said the lawyer looked like a puppet when someone cut the strings. Boyfriend became a guest of the state for a long time. Puppet with the strings cut. I think I'm going to steal that burn and use it. That is hilarious. Great play on words. Next story. My mother left my dad and hooked up with this piece of crap who would beat her. She had him arrested and got a restraining order. He called her one day from the hospital and said he was jumped while riding a bike, and if she didn't take him back, he would say she did it. A few months later, she's in court after he claimed his injuries were from her beating him with a frying pan. He doesn't show up. Judge asks his attorney where he is, and the attorney asks if they can reschedule because he's temporarily indisposed. Mother chimes up, and he's probably in jail again. The judge asks his attorney if he's in jail. The attorney's response, "Yes." The judge immediately dismissed the case. Next story. I was in court on a speeding ticket, and the case before mine was Fred, the town drunk. It went like this. Judge says, "Fred, the charges here say you were arrested Saturday night in town drunk. How do you plead, Fred?" Fred says, "I don't know." "What do you mean, Fred? Were you in town Saturday night or not?" "Well, that's what I don't know. I have no idea where I was Saturday night, but if I was in town, then I damn sure was drunk." And the judge chuckles and says, "Okay, Fred, how's $25 sound?" Next story. I'm no attorney, but I once fought a complete crap citation, and the officers who wrote it up knew they had pulled it out of their arse and did not bother showing up when I appealed it to Superior Court after losing in a kangaroo little court where I saw the officers meet and laugh with the judge beforehand. A respected attorney and friend of the family was a little disturbed with the situation and offered to represent me. The judge took his seat. The case was read out. Then the judge turned to my attorney and said, "What magical words do you have for me today, John?" One of the best feelings in my life. Next story. I'm on the defense side arguing that my court-appointed client didn't steal from Walmart. Walmart does not F around with their loss prevention. My guy wanted to see the Vita, so I subpoenaed it. That's got him on it. Talking crap, trying to return a different item, getting apprehended, etc. Watched it before trial. He still wants to go to trial, and it's not like I can plead him guilty. So I have to argue it's not him. After the ADA and I finish with the loss prevention officer client goes up on the stand to contend it's not him. ADA's turn on cross, rips him apart. Guy says he guesses he did it. Judge says, "Any redirect, counsel?" And I say, "No further questions, Your Honor." The guy later says he might have been drunk when it happened. He then wants to appeal it after the 10-day notice requirement is up. Thankfully, my representation terminates past that point, so I just told him to file a motion for appropriate relief and pray. I'm sure that was a great moment for the ADA. Next story. Not a lawyer, but I'm aware of a case where two people were injured in a rollover motor vehicle accident. Both were ejected, and there arose some dispute as to who was driving. The accident occurred in a rural area. One or both of the occupants moved before emergency services responded, and one of them sustained a head injury and lost memory of the accident entirely. The driver's counsel hired an expert engineer to show that the injury sustained by his client, who was actually the driver, could not have been caused by striking the dashboard and steering column. The passenger's attorney, the plaintiff, in a personal injury suit against the driver, had no such expert. Only Trooper Good-Old-Boy, who had worked probably 1,000 such accidents in the course of his career. The defense expert, who was a former NASA engineer, went into a very sophisticated demonstration of force and trajectory that was legitimately slick and impressive, but lacked substance. The plaintiff's witness, Trooper Good-Old-Boy, answered each question with a drawled yes or no, and simply stated he's seen injuries such as the defendant's. It happens when a knee strikes a steering column at a high rate of speed on its way out of a tumbling car. The plaintiff had injuries consistent with the 1,000 or so passengers he'd seen in the course of his career. Try as he might, the defendant's counsel couldn't shake him. Plaintiff's counsel largely ignored the expert. At the close of evidence, the defendant praised the math skills and conclusions of his own expert in closing arguments. Plaintiff's counsel sat without emotion. At the end of plaintiff's closing argument, pointed out all the inconsistencies and how the NASA engineer was wrong, then said, "It doesn't take a rocket scientist," pointing to the expert to find for the plaintiff, which the jury did.